Like, don't move out. This is a big mistake.
The retribution.
We're talking about credibility shot for sure.
Well, now it's illegal.
Yeah.
So
sometimes that affects your home sale.
don't go off and make any moves.
Well, what happened with this house?
That would be a cardinal sin.
Hi, everybody. Welcome to Uncoupled, episode 2. And I am joined today, for those of you who are new here, with my guest attorney, Maiya Safikovs.
Hello.
It's always a pleasure. Thank you for joining us.
Thank you for having me again.
So today we're talking about restraint. We're talking about what not to do before you file, because even though some moves may feel harmless, they can create big problems later.
Yes.
Okay. So Maiya, how are you?
I'm doing well. How are you, MaryJ?
I'm good. How are things? I know that there's been some changes, recent changes in January with child support
There has
laws.
been.
So let's get right into some of that. I just want to kind of jump into that, and then we'll talk about what not to do.
Sure. So in January, our child support worksheet got an overhaul. The overhaul actually started about a year and a half ago, but everything was unveiled as of January 1st of this year. Our child support worksheet is a worksheet. It's exactly what it sounds like. So back in the day, child support used to be a percentage of the non-custodial parent. So that's the party who does not have custody of the children. It used to be a percentage of his or her income. We deviated away from that in 2007, and our legislature adopted a worksheet that contemplates the gross monthly income of both parties, and then we put in expenses for the child, and whoever is paying that gets credit for it on the worksheet. The worksheet then spits out a number, and that determines that other party's child support obligation.
Gotcha.
Well, as of January 1st, the worksheet now gives a credit for parenting time. So if a party, and just for ease of reference, let's say a father doesn't have custody, mom has custody. Let's say that dad is getting the child every other weekend, and he's splitting the summers and splitting the holidays. Well, the worksheet now counts the number of days that father has the child. Then the worksheet gives dad a credit and reduces his child support amount for each day that he has the child. So the more that you have your child, the less that you pay in child support.
So you're almost rewarding people for time with
Exercising
their
parenting
child.
time. Yep.
Benefits the children more than anything.
Yes. Yes, it does. So we'll see if that's going to change the landscape, if more non-custodial parents are going to fight for more time in order to get that deviation.
Yeah. Sounds good. Okay, let's talk about some things people may do that they think is harmless, like hiding money. Things that people may do to kind of protect themselves, because of course when you're in this early phase, you feel like you want to kind of go into the self-preservation mode, and so you may feel like there are some things that you need to kind of put aside or start building for your own self to be okay. So, but what these things can be harmful too. So tell us about some examples you've seen that have turned really bad fast.
Yes. So first off, a judge will, unless the parties mediate, a judge will be the trier of fact, and sometimes a jury, determining what's going to happen with assets and debts.
Okay.
And judges and jurors are not, they're not green. They weren't born yesterday. So they can see if you had a large amount of money right before you filed for divorce, and then you file for divorce and that money is gone. They will be able to see that in a paper trail. One thing that people do that they think is harmless is trying to hide money, trying to move money around, taking money from his or her personal savings and putting it in their parents' account. All of that is captured. If you have financial accounts, unless you deal 100% in cash, all of that is going to be captured.
A paper trail.
And a judge will be able to see what was going on. And most of the time, judges make you recover whatever the other party should have received from that pot of money. And if I had this happen where a party took money from another party, and we went to court, the other party was destitute and didn't have the money. what the judge did was award property to my client
Ooh,
to make up for the difference, and it shot that other party's credibility.
I bet.
So the judge just did not believe anything else that that party stated during the course of the litigation.
And that credibility is that is the one thing that can kind of help you
Mhm.
or hurt you
Yes.
throughout. You don't wanna damage that early,
Yes.
right?
Another thing that people is it seems so innocent, but it can really hurt your case. Taxes.
Hmm.
When we are preparing our taxes, now with the onset of TurboTax, there's
Yep.
so many people who self-prepare taxes.
Yes.
And maybe you put you say that you have a side business there so you can create a loss by taking certain deductions.
Mhm.
Well, when you do that, then you're going to have to answer for the court. Did you have this side business? Where are the records of this side business? Did
Mm.
this side business bring in some gross receipts? What are those gross receipts? What type of industry are you working in? Can we argue that that side business could bring in money later on that would
Right.
allow us to impute your income or assign additional income to you?
Yep.
So those are things that we have to take into consideration. Not being honest on taxes, some judges don't like that because if you're not being honest with the IRS, are you
Yeah.
going to be honest and credible in the judicial system?
Absolutely, absolutely. And then what about folks who like to make unilateral decisions like, trying to sell their house,
No.
trying to, kind of take the property early and
So that is an extreme no.
yeah,
What typically happens if an individual is trying to sell a house without the permission of his or her spouse, then that spouse needs to immediately file for divorce. Even if you're not ready to divorce, you need to file some action. The other option would be what we call a separate maintenance action. But you need to file something so that you can get court intervention and so that you can get protection from something known as a standing order.
yes,
That by filing the action, the divorce or I'm sorry, this real estate sales
has
process
to
must
halt.
stop.
Mhm. Yep.
And nothing can occur. Now, typically, if parties purchase a home, both of their names are on the deed. However, if the other party's name isn't on the deed, then the one party can go ahead and sell the home out from under
Sure.
the other party.
And let me tell you, as a real estate agent, if you've listed your home for sale and then you withdraw the listing because of your standing order, and then you post it again for sale, the market
Mhm.
looks at sometimes that affects your home sale.
Mhm.
The other party, the buying party is going to say, well, what happened with this house?
Mhm.
Was it priced too high? They're
Yes.
trying to figure out why you took it off the market. And so you lose credibility in the market too.
Yes.
So
Yes.
it can hit you twice as hard.
Well, you lose credibility in the market, and then you also may lose your spot in the market. If you
Yes, that's
approach
true.
this process correctly and you get the permission of your spouse and you ensure that your spouse has equal access to the real estate agent, that the spouse has equal access to the listing agreement, that you have an agreement that you're going to follow. And in all of my settlement agreements, I state that the parties will defer to the listing agent because you are the professional. But
Yes.
if you have that agreement with your spouse, then you're able to go ahead and list so that you can take advantage of the spring market.
Yes.
Um,
The
and
first
mhm.
listing, the
And
initial
if you play
movement,
games and if you make unilateral decisions, then you may lose that
that
opportunity.
spot. Yeah.
Hmm.
Yeah. And you want to get your house seen as a new listing. You
Hmm.
don't want it to be a return listing because folks have already seen it and they've already started asking questions. So yeah, yeah,
Yes.
agreed. It's not going to be the same. So definitely want that first impression to hit.
Yes. Something else that I know can affect your process is debt, the
Hmm.
accrual of debt and the paying off of debt.
Yes.
And the moving of money can affect
Yep.
getting pre-approved as
Sure
well.
can.
And
Hmm.
so making those decisions. So some individuals will say, well, I'm just going to stop paying my debt so that
Hmm.
he or she will have to be responsible for part of it.
Mm.
That could greatly impact your ability to refinance.
Yes. Yep.
So again, I know the last time that I was here, we spoke about the importance of always consulting professionals. And
Yes.
before any decision is made, you want to consult with
Mhm.
a real estate agent.
Right.
And so,
Lenders will not like to see that you moved money around.
yes. So I have a question for you.
Mhm.
So if someone is interested in your services, do they just contact you and set up an appointment, or
So
how
I'm
does that
glad you
work?
asked that because I am available through I've got my website, MaryJ, ATL. If you are not familiar, you can go on the website and a lot of my services you can do through my website. You
Okay.
could do a home valuation. You can check your mortgage.
Oh,
You
wow.
can check and see if there's a pre-approval. There's a pre-approval link, so you can see if you can get pre-approved. I also offer free consultation.
Oh,
So
wow.
there's no obligation and no fee to consult with me. Our podcast is here for information, so um, feel free to drop a comment. And if you're interested in that free CMA, just drop CMA in the comments.
And so
Also,
CMA is the comparative market
it
analysis,
is,
right?
it is.
Okay. And I can tell you that that is what I encourage my clients to heavily rely upon
Okay.
when valuing homes, or going
Yes.
through this process, and when deciding what to do and what not to do. And
Yes.
so that could be a guiding force. So that's an awesome
Absolutely.
tool that you
And
offer.
appraisers are going to charge you. A CMA will
Yes.
not a realtor is typically not going to charge for that. So you can check that at any time. You can reach out to a realtor. You can get multiple valuations done. If you're unsure about one valuation, you can get the next realtor to give you another one.
Okay.
So,
Awesome.
yep, I always recommend that. So, don't go off and make any moves. Check first, right? All right, and then let's talk about damage because I know that a lot of times when we come in as realtors to sell a house, we see that there's been damage done to the property, and it's because one person stayed in the house during a divorce or a separation, and the other person left, and that person who left has no ability to kind of see things. So, talk about like for that early phase of divorce, if people are separated and one person has moved out, and you're the one staying in that home, what damage to property could do, how that could kind of you know go against you, I guess, in the state of legal
Certainly.
proceedings.
So, no matter what stage of a case you're in, if you decide to go through with full throttle litigation,
Mhm.
or if you settle in mediation, you always are going to want to have evidence. And if the parties are indeed separating and one party is leaving the home while the other party remains, I highly recommend taking pictures, taking
Mm.
photographs of the state of the residence at the time that that party left. Now, most judges are going to assign the cost of ordinary wear and tear expenses to both parties.
Okay.
However, if it's something more, such as holes in the walls, or if there's extensive water damage
Yeah.
that was done by fault and not just by poor plumbing,
Mhm.
then that's something that may need to be assigned and assessed
Yeah.
to the party who caused that issue.
Yeah.
So you want to have your evidence as to what the home looked like, what was the state of the home before the other party left.
That's good. Okay, good to know
Mhm.
because that will affect your
Mhm.
equity.
It will.
You have to kind of factor in a allowance or credit to the buyer for
Yes.
repairs that are needed. So all of that is important.
Yes.
Mhm. Okay, and then what about writing? A lot of people put things in writing. We talked about social media in the previous episode and the issues with that. But what are some things that you should clearly avoid putting in writing through text message or email? Um,
Well, any admission of guilt or fault, don't put that in writing.
okay.
But I have found that if parties are separating, and there are agreements that are being made, then it does need to be captured in writing.
Okay.
So, for example, if one party is going to be leaving the home and the other party says, okay, I'm going to stay here, I'm going to be responsible for the mortgage, but I'm going to need you to help me with half of the utilities. And the leaving party says, okay, I can do that. But
Oh,
then he or she does not. If you don't have that in writing, then there's no way to prove that that was just an oral agreement. It's
and I
he
guess in the
said
flip
versus she
side,
said.
don't put it in writing unless you are
Yes.
willing to be
Yeah,
committed to
committed
that.
to it. Yes, yes,
Interesting.
yes.
Okay.
And I don't think that there's anything else that wouldn't necessarily need to be in writing. I do know that a common trend is for individuals to say, well, I'm taking out a loan from my parents or a family member, but I have to pay it back. That would need to be in writing. That would need to be in a contract. If you want the court to consider that when dividing up the marital estate, and you want that to be considered a debt that both parties need to be responsible for, that would need to be in writing.
Okay. Okay. That's good. All right. And then if you're moving out of the marital home, you mentioned, no, we talked about this before, people who just need to keep the peace sometimes.
Yes.
But when is it a mistake? Like, when would it be considered, like, don't move out? This is a big mistake.
So, if it's going to be a long divorce process, and if you are peaceful, I would not move out of the home.
Okay.
If custody is going to be contested and you do not have an agreement on a temporary basis as to
Mm,
where the children will be, I would not move out of the marital home because you want to continue to stay involved with the children. You want
gotcha.
to continue to be there with the daily routine of homework, bath time, getting them dressed for school, etc. That is when you should not move out.
All right, coffee talk time. So
All
this is
right.
our favorite segment. It's where we kind of leave things to kind of be discussed kind of off camera but on camera. And so don't take any of this as legal advice. This is us talking about real issues and having real conversations. Maya, during this coffee talk time, I have to ask you, most of us women, we feel like we want to kind of like have that little stash of money put aside to protect ourselves and our children. Is there any good way to do this, a right way to do it? Let's just talk about if you know that this is like your niece you're trying to protect, if this was not a client and you know that they need to, they're not working or maybe they're, just working bare minimum part-time. Um, and you're like, yeah, they're gonna need to have a stash. Is there
Yes.
a right way to do that?
So, I don't know the last time I was here, we spoke about equitable division, and we
Mm,
spoke about the fact that any money that was accrued during the course of the marriage is subject to division.
right.
Even if you have a nest egg that was put away as your secret stash, if you were contributing to it during the course of the marriage, then that's gonna be subject to division, and
Okay.
that would have to be
What about
disclosed
if
to
I
the
say
court.
if it's a gift, if you ask your spouse, "Are you gifting this?"
Well, what I was gonna say is that I guess the clearest way to do that, and this is not I wouldn't recommend this, but
Uh-huh.
it would have to be cash. You would
Okay.
have to maintain cash, but knowing that that would be still subject to equity,
Okay.
and being divided, but that's the only way. Now, sometimes arguments can be made, especially if the other party has far more money. Some people who hire me, they are using that stash to hire me at the
Uh-huh.
beginning of a divorce. Perhaps their husband holds the purse strings, and they are using that little nest egg that they put away
Yeah.
to help pay for me and to pay for expenses until we can get through the litigation process. If that's the case and the other party has been financially controlling, then you don't have to worry about that. There are enough legal arguments and defenses that
Mm,
can be asserted to protect what you had.
okay.
Now, it's also to note that um, sometimes, like I had a young lady come to me and she is represented, or I'm sorry, she is married to a celebrity. She has no money. She had no money whatsoever. She had a small little nest egg that she was able to use to pay my retainer. And what we're able to do is to pursue her husband for the attorney's fees,
Okay.
pursuant to it's a statute in Georgia known as 19-6-2, which
Okay.
is designed to level the playing fields between divorcing spouses so
Mhm.
that the higher earning spouse does not have stellar representation while
Right.
the lower earning spouse does not.
I love that. Yeah.
Yes.
That kinda evens the playing field a bit.
Yes. Yep.
Nice. We are back from our coffee talk segment,
Yes.
so I hope everybody enjoyed that. We're going to go to our second part of this, and we're going to talk about a little bit more about the marital home and what are these big decisions that can create long term consequences. So I've got a scenario I'm going to pose to you, and then I'd like to kind of hear your thoughts, and we can talk about that a bit. So this scenario is a person that starts Googling ways to change their title or remove people's names from the house. So we know that Georgia's an equitable division
Mhm.
state, and that person's name being on the title is not the deciding factor.
Correct.
But let's talk about that just a bit because we know that this happens. People are looking for ways to kind of minus that person off.
That would be a cardinal sin. Um, that would be illegal to remove a party's name from title without his or her knowledge. That would be illegal.
Okay.
The havoc that that would cause and the negative impact that a trier of fact would cause, the retribution would
We're
be
talking
so
about
high.
credibility
Yes.
shot for
Well, not
sure.
only that, it's illegal.
Yeah.
So
Yeah.
I was in Rockdale County about a year ago, and I
Mhm.
was waiting to be heard for my case. And I saw in front of me the court was conducting a bond hearing for a lady who had removed another party's name from the title of the home. And
Mm.
she had done that. It didn't sound like a huge criminal act because what she'd done, she just forged a signature, took it to a notary
Yeah.
and signed there, and then filed it with the deed office. Her bond was $1 million.
Ooh,
$1 million. That is how seriously the court
man.
system took it. $1 million. There are individuals who commit murder and their bonds are
Right.
less than $1 million. So that shows how
Sheesh.
grave of an infraction that is.
Mhm. Mhm. I bought a house before when I was not a realtor.
Oh.
And it was an investment property, and we closed the deal in the courthouse, and it was just some guy from, I think it was Craigslist, popped
Mm.
up and said that we were closing the deal on this tax sale property, and all I had to do was pay the back taxes, so I closed the deal with them in cash.
Oh, wow.
They gave me a document that was already pre-signed, and I signed as the buyer, took it to the courthouse. Everything was done. Years later now, I had signed that property over to another buyer,
Mm.
because it ended up being a horrible, horrible investment for
Uh-huh.
me and my family. As it turns out, that previous owner filed a claim and said that they had someone had forged their signature,
Wow.
and they were asking for the property back.
Yes. So that's why
And
it's
so it
always
happens
important.
for
Yes.
sure.
That's why you have to use a professional.
You do.
You have to use a professional.
You do. Yep. So, good lesson. After that, I became a realtor and
I
decided I was
see.
going to try to make sure this was legit going forward
Yes.
because, things like that could really, I mean, imagine if that investment, if I had to put a lot of money into that
Mhm.
property and years down the line, somebody comes and says that sale was fraudulent,
Well, and then
you know?
there are criminal implications there as well.
Right,
I'm
right.
sure there could have been an investigation
Yeah,
with that
yeah,
just would have not been good even though
right,
you were the innocent party.
right. All right. So we know that sales of homes are usually faster and better when you've done some repairs and remodeled and done some updates, right? But
Yes.
in divorce scenarios, you're not always able to do that, right? Because now you got to talk about who's going to spend the money to do that and
Correct.
things of that nature. Um, when does this become a problem? Like, how do you navigate things like that to kind of determine who's going to get this house ready for the sale? Or is there anything that you can put into the divorce agreement to talk about that?
Yes, that is perfect. I typically like to write in an order, even if it's a contested order or if it's a settlement agreement, that the parties will defer to the advice of the listing agent. Because again, the parties, unless they're real estate professionals, they don't know what is necessary to get
Mhm.
the to what improvements to make to get the biggest return on their
Return.
investment.
Mhm.
Nor do judges, nor do attorneys. So we defer to the listing agent. That way you have an objective party
Yes.
who doesn't have a dog to fight and a dog in the fight, so to speak, who can determine this is what needs to be done in order to get more money. So I know in one of my cases, it was as simple as fixing a doorway in their home and then fresh paint, new carpet. That expense was, I believe, $3,000.
Mhm.
They were able to demand an additional $20,000 for the sale of their home. So
Yeah.
that was a good ROI.
Yeah, and sometimes it's as simple as just cleaning out the house, the
Mhm.
clutter out of it, and just kind of putting some things out of the visible eye, and that can help the buyers to kinda see themselves in the house, and you can close a lot faster that way.
Yes.
So, yeah. Alright, and then let's do another scenario. So let's say this person, hasn't filed yet, and they open a new bank account. They start to pay personal expenses with marital funds, and in this situation, certain actions start leading to this person is operating in silo, right?
Mhm.
So silo actions in general, just them protecting themselves or doing things to kind of even if it's involving the kids or not involving the kids, just operating in silo throughout the marriage, is are there any repercussions for early silo actions?
So I would use that when the judge is making a determination of equitable division. I would use that to say that that spouse had 100% discretionary use of his or her own income, while my client was having to use his or her income to foot
Had
and
no
support,
action access,
yes,
yeah,
and to support the rest of the marital estate. And so this was done stealthily. It
yeah,
wasn't done with the consent and knowledge of the other party, so
mhm,
they should not be awarded for such bad behavior.
yeah,
And so the way to equalize everything is for the court to exercise his or her discretion as it relates to the equitable division and give a higher portion of the marital
okay.
estate.
Because 'Cause we've seen this, right? We've seen
Yes.
people cancel joint credit
Mhm.
cards and cutting off the other spouse from access and just, you know
Yes. Yeah, that's unfortunate. It happens a lot, and it needs uh, to prevent that, there needs to be a divorce action filed
Okay.
because that status quo, whatever was formulated and put in place beforehand, the divorce action freezes that status quo. So if you had
Yes.
access to a credit card, if you had access to a bank account, and those funds were being put in, you file the divorce action, you have to get that access back.
Okay. Great. I love it. I love that all of these things are in place to kind of help create fairness and,
Mhm.
just making sure that both that it's not one-sided going
Mhm.
forward, right? Okay, so let's talk about the final thing here I'd like to talk about is agreements. When people we talk about, putting things in writing and people having their own agreements, you've got faith-based agreements.
Mhm.
How do those things, is there anything folks should avoid agreeing to or, making these agreements before divorce is filed? How do these
Yes.
affect you?
So the only Georgia is a great melting pot,
Yeah.
and it has become more diverse over the years. However, we only abide by the official code of Georgia annotated OCGA and our state
Mhm.
constitution. Um, Unfortunately, so I'll see this a lot in the Islamic community
Mhm.
where there are individuals are Islamically wed or they're
Mhm.
Islamically divorced. We
Yeah.
don't honor that. We honor when you were legally wed and when you were legally
Oh, okay.
divorced.
Okay.
So that's what we look at. So if there is a contract outside of that, that's up to the discretion of the judge. But those are the dates that we're going to look at.
Okay.
I've had cases where the courts have had to make a determination as to whether or not, speaking in the Islamic realm, whether or not we're going to honor the mahar, which is a dowry,
Uh-huh.
and that's usually put in place. And it again, that is going to be up to the discretion of the judge. The
Mhm.
case that I tried that dealt with that dowry, the judge said no. I mean, my client, the dowry was something like $5 million.
Yeah, I was gonna say
Yeah.
internationally, those mahars can be pretty big, right?
Yes.
Those dowries.
Yes. And
And
so
yeah.
he it was $5 million. My client made $100,000 a year. We could not honor that.
Mhm.
So the judge threw it out.
Okay. So
Oh,
that's
we do honor, legal postnuptial and prenuptial agreements. So, prenuptial agreements are which you enter into in contemplation of marriage. Postnuptial agreements are when you're already married and you decide, "I want a prenuptial agreement, but we're already married."
Oh, god. Okay, let's double
Yes.
click on that a little bit. Let's talk
Okay.
about that. So, are there any things that we should not do if you are thinking of going on and creating a postnup, right? Is
Mhm.
there anything that you would say is a red flag? Do not move
So
forward with this if you're in this scenario.
So if you are being presented with a postnuptial agreement and it has your spouse getting a larger share of the assets than you should, then no, do not sign. Or if it's going to be an absolute waiver of alimony and you are completely dependent upon that party, then do not sign it.
Mhm.
Now, neither prenuptial agreements nor postnuptial agreements can outline custody or child support. That's not
Okay.
allowed.
Okay.
But if a prenup or a postnup says that you will not be entitled to attorney's fees if there's a divorce, do not sign it unless you and your spouse are truly financially equal.
Got it.
Another rule with prenuptial agreements to make sure that they are ironclad and that they are not challenged, you want to ensure that the other party has adequate legal representation. So
Mhm.
both parties need to have attorneys read these documents and to give advice.
Yep. This should not be done at the kitchen table
Correct.
and just signed by a notary.
Yes, and you must make a full disclosure of
Mhm.
all assets and debts.
Uh-huh. Uh-huh. I know a lot of folks who have their own businesses and are CEOs. They do these
Yes.
because, they put in a lot of work to build their business. So I completely understand it. You don't want to build something and then have it torn down later through a
Mhm.
divorce, right?
And it keeps the divorce amicable because you
Mhm.
know what you're going to do. It keeps it cost effective. If
Yes.
you have children, then there's no bitterness.
Yeah.
All you're doing is deciding custody and child support from there. Most prenuptial agreements will already speak to whether or not there will be alimony, if there
Yeah.
will be alimony, the amount, if there's a schedule of alimony, and then how you will divide up the assets. Premarital agreements also will outline what is considered premarital,
Mm-hmm.
and what is considered marital.
Yeah. Great. So this is a tiny attorney Maiya Safikovs, our family law attorney here in Georgia, and I'm Jamila Issa, MaryJ, our divorce realtor here in Georgia as well. And this is the show Uncoupled. Thank you so much, everyone, for joining us, and we'll see you next time.
Thank you.